Good evening. I'm A.G. Harmon, Faculty Director of Bench and Bar Programs here at the Columbus School of Law at the Catholic University of America. Tonight, we begin the first of what will be an annual series, the Seigenthaler Debates, named in honor of journalist, publisher, and free speech advocate, John Seigenthaler. This debate is part of the First Amendment initiatives here at our law school, a series of programs that provides a collegial forum for fostering the dialogue and study of First Amendment issues from all sides. Catholic Law is proud to be a leader in this area and also sponsors the Seigenthaler Sutherland Cup First Amendment Moot Court Competition, which is the oldest national competition of its kind, the Judicial Clerkship Opinion Writing Conference, in which rising judicial clerks are instructed by the judiciary on how to write judicial opinions using First Amendment issues, and the Center for Religious Liberty, dedicated to the study and articulation of the Catholic approach to religious liberty as a fundamental human right for all persons, regardless of faith. This debate is being co-sponsored by the Free State Foundation, a nonprofit, nonpartisan think tank that promotes free speech and advocates laws and policies true to that principle. Special thanks to Randolph May, president of the Free State Foundation, for his great help in bringing tonight's event together. Also, thanks to our school's chapters of the American Constitution Society, the Federalist Society, and the Law and Technology Student Association for their support. This debate is being co-sponsored by all of these folks, and also we want to understand that the first proposition in this inaugural debate is internet platforms should be treated like common carriers, a possibility suggested by Justice Clarence Thomas's concurrence in Biden versus Knight First Amendment Institute. A word about the format of the debate. In a moment, I'll turn the floor over to my colleague, Marshall Brieger, ordinary professor at the Columbus School of Law. Professor Brieger will introduce our two debaters, Professor Eugene Bullock of UCLA Law School and Professor Ash Bhagwat of UC Davis Law School, as well as our moderator, Judge Lawrence Van Dyke of the Ninth Circuit Court of Appeals. After those introductions, Professor Brieger will ask each of our debaters for an opening statement. He will then turn the floor over to Judge Van Dyke to conduct the debate. Once Judge Van Dyke concludes with his own questions, he will pose questions posted by the audience in the chat feature of this webinar located at the bottom of your screen. Please note that the Q&A feature and the raise hand features have been disabled. So again, post your questions in the chat. That said, again, welcome. And I'll now turn things over to Professor Marshall Brieger for the introductions. Professor Brieger.
Thanks so much, AG. Our first speaker is Eugene Bullock. Many of you will know him as founder of the intensely provocative and always interesting blog, The Bullock Conspiracy. So he knows his internet. And when not blogging, he teaches at UCLA and is one of the leading First Amendment scholars in the US. Before he fell into teaching, he clerked for Judge Alice Kaczynski on the Ninth Circuit and Justice Sandra Day O'Connor on the Supreme Court. And prior to playing around with the law, he was for 12 years a computer programmer, which gives him an even deeper perspective on tonight's topic. Our second speaker is Ash Bhagwat. And my question to him is, with all your scholarship, where is your blog? I'm sure it's coming. Professor Bhagwat teaches at UC Davis and is the author of an extremely interesting book, The Myth of Rights, published by Oxford University Press, and numerous articles in law reviews, including Yale, California, and the Administrative Law Review. He clerked for Justice Posner, Richard Posner, on the Seventh Circuit, and Justice Anthony Kennedy on the Supreme Court. Both he and Eugene Bullock have written trenchant articles on the questions of internet regulation. So it's really exciting that they can join us. Our moderator is Judge Lawrence Van Dyke from the Ninth Circuit Court of Appeals. And he has the unique, I have to say, really unique background of serving as Solicitor General of two states, Nevada and Montana, and before that, Assistant Attorney General in Texas. So he really knows his states. And with that experience, he naturally became Deputy Attorney General in the Environmental and Natural Resources Division at the Department of Justice. He clerked for Judge Janice Brown on the DC Court of Appeals. And before that, he studied both engineering and theology at Harvard. So we're going to have you back, Judge Van Dyke, to speak, Catholic, to speak on the argument about, from design, which requires both engineering and theological skills. Without further ado, I give you Eugene Baum.
Thank you. Thank you very much for having me. So I think I'm supposed to argue that social media platforms should be treated as common carriers. Deep down inside, I'm actually not sure. And my article on the subject in the Journal of Free Speech Law explains why I'm not sure. But, you know, this is supposed to be a debate, so let me take that position. Let me argue in favor of it, recognizing that I do think it's a very close question. I think as a constitutional matter, they probably can be treated as as common carriers, but that doesn't necessarily mean that that's a good idea. Not everything that's constitutionally permissible is actually wise. Let me try to explain though why it might be both constitutionally permissible and wise. And let me start. I'm trying to share the screen. What's going on? Why am I not doing that? Share screen. Share. Do you see my PowerPoint deck? Good. Good. So let me start with a quote from Justice Stevens. Now, this is from the dissent in Citizens United. 4 of the 9 justices signed on to it, so the majority didn't. But I think that his insight, while I actually don't agree with it in Citizens United, I think it's pretty powerful and might be quite applicable to the social media platforms. At the very least, if you think that he was right in Citizens United, as very many people do, certainly lots of academics and intellectuals and newspapers argued that the dissent had it right in Citizens United, you might want to ask why that shouldn't be applicable to social media platforms. So here is Justice Stevens's reasoning. Remember, the question in Citizens United was whether corporations should even be able to speak themselves in support of our opposition to candidates. And he argued there are good reasons for the legislature to say no. The legislature might conclude that unregulated spending gives corporations an unfair influence and distorts public debate. Concern is about a large corporations' economic power being leveraged into political power. That, he said, might lead the opinions of real people to be marginalized. Restrictions on corporate expenditures, which is really restrictions on corporate speech, are meant to ensure that a competition among actors is truly competition among ideas and not among who has the most economic oomph. Corporate domination of electioneering can also generate the impression that corporations dominate our democracy. I think something similar could be said about social media platforms. Not that they do that much moderation now, but they're beginning to, and to the extent that they do, they certainly have an outsized influence on our democracy. And politicians who fear that a certain corporation can make or break their re-election prospects may be cowed into silence about that corporation or possibly about other matters. Now, again, I actually don't agree with Justice Stevens on this because I think that corporations should be free to speak. But while his reasoning, I think, is forceful enough, even though I'm not ultimately persuaded with regard to corporate speech, but I think it applies even more to corporate restrictions on individual speech. When you apply this to a situation where a corporation is actually blocking speech, not just risking supposedly metaphorically drowning it out with its own speech. In fact, actually, corporations don't spend that much money speaking about candidates, relative to other speakers. But when you have them not just speak about candidates, but actually block people's speech, whether about candidates or about issues, or about a variety of other things, there, it seems to me, this concern that Justice Stevens pointed to about economic power and immense economic power in the context of some, at least, of the big tech companies, this economic power being leveraged unfairly into political power. Now, one way of thinking about it is to think about the spectrum of platforms. And by platform, I simply mean a place that publishes or publishes or distributes other people's speech. On one side, newspapers and magazines. There, I certainly don't think that a newspaper or magazine should be viewed as a common carrier or required to allow all speakers, even all speakers without regard to viewpoint. Particularly think of magazines. So you might subscribe to the New Republic or the National Review, but you do that precisely because you like its editorial viewpoint. If they had to be neutral, that would actually deprive us of important options, especially since newspapers and magazines also function to deal with the problem of information overload. That a newspaper and a magazine are valuable for as much for what they exclude as what they include. Even if I subscribe to a ostensibly nonpartisan newspaper, a non-ideological newspaper, I wanted to exclude things that are badly written or seem to be likely wrong or even ideologically out of the mainstream in a way that they think would not be interesting to their readers. I think something similar may be true for bookstores too. Now, bookstores carry a lot more books than a typical newspaper carries articles, but still, you have feminist bookstores, you have Catholic bookstores, you have free market bookstores, you have libertarian bookstores, you have socialist bookstores. There's value there too, because again, they solve the problem of information overload. You go to one of those bookstores and you can be assured that the books there are ones that you would be inclined to, because presumably you're going to that bookstore precisely because of its ideology. I'd say the same about Google as provider of search. A search engine that's content neutral is useless. I mean, imagine a search engine that gave you a random web page, not very helpful. Even viewpoint neutral is probably not what you want. If I ask, what's the age of the Earth? I presumably want it to give me whatever number of billions people think it is these days, people being scientist people. If they say, oh, people say it's 6,000 years, I think I'd say, that's probably not what I want to know. I wish you'd given me something that reflects a more mainstream viewpoint, more scientific viewpoint. And I'd say the same, by the way, as to social media platforms for their recommendation function. When they recommend pages you might like, I think they're operating like newspapers, like Google search. They are winnowing out of this universe of possible options, something that they are willing to stand behind. That, I think, is their First Amendment right. That's also something that's valuable for users. And by the way, it's an interesting question where we fit situations where Facebook, YouTube, and Twitter, and by YouTube, I simply mean Google in its YouTube product, manage conversations, comments by outsiders and users' pages or tweets. But then let's look at the other end. What about the Postal Service? There we do have it be a common carrier as a First Amendment matter. It's run by the government. And I think on balance, we think it's good. We think it's good that the Postal Service won't say, no, these are really evil ideas that are being sent through the mails. And we don't want them on our property. It's going to undermine our brand for people to know that the post office is being used for misinformation and disinformation and malinformation and communists and Antifa and fascists and whatever else. No, we say, no, you guys should be viewpoint neutral. Now, that's because they are run by the government, but the same thing is true for UPS and FedEx. If UPS and FedEx says, we refuse to deliver things from a socialist bookstore or socialist publisher, let's say, because after all, what if socialists want to do with us? They want to destroy our business model, and we don't want that to happen. You can understand why FedEx or UPS might want to block things for that reason, but they can't. They're common carriers. Likewise with a phone company. Imagine a phone company knows, it isn't listening in on any conversations. It just knows from flyers or web pages that there's a phone line that's being used for recruiting by the Communist Party or by the Klan. And the phone company says, we refuse to allow that on our property. We are property owners and we cannot be compelled to allow speech on our property. The answer is yes, you can. You're a common carrier. You have to allow all speakers, of course, all speakers who pay for a phone line. There may be other kinds of viewpoint neutral restrictions that might be imposed as part of the common carrier regulations. But generally speaking, you can't just block things just because it's on your property, which to be sure is your property. By the way, that's true not just for regulated monopolies like landlines, it's also true for the famously competitive cell phone operators. So the question is, should Facebook, YouTube, and Twitter, as providers of hosting for users who want to reach willing viewers, at real Donald Trump, people want to subscribe to that, let's say, Should they be treated more like those phone companies? And for our purposes, I will argue yes. And I do think there's a very good argument that the answer is yes. Now, what about the First Amendment? I just want to touch on that. We'll have plenty of time to talk some more about it. Here's a quote. This is from a dissent by Justice Breyer for 3 justices, but the majority, if anything, was even more skeptical of First Amendment arguments against compelled hosting obligations. Justice Breyer says, requiring someone to host another person's speech is often a perfectly legitimate thing for the government to do. Now, often, not always, but often. And why? Well, let's look at 5 cases. 2 of them famously said the government can't require entities to host other speech. Newspapers can't be required to publish replies to speech of candidates. Parade organizers can't be required to include floats they don't like. This roughly maps to the top of that spectrum that I mentioned a couple of slides back. But in the Pruneyard case, the court said a shopping mall may be required, if state law so requires, to allow leafleters and signature gatherers on a content-neutral basis, even if the shopping mall owner doesn't like that speech. In Turner Broadcasting, the court said a cable system may be required to carry broadcast channels, even if that means that the property owner has to carry speech that it may disapprove of. And in Rumsfeld v. Fair, the court said a university may be required to allow military recruiters. Now, the actual statute there was a condition of funding, but the court said that would be true regardless. It would be true even if this was an categorical mandate. No, neither of these cases is completely on point. Turner Broadcasting, for example, involved things that were basically regulated monopolies, like cable operators. But shopping malls aren't monopolies. Universities aren't monopolies, right? So I think those 3 cases put together suggest that when we're talking about say, Twitter deciding what to host, again, not what to recommend, but what to host, Facebook deciding what to host, YouTube deciding what to host, that seems to be a lot closer to university being compelled to include recruiters that it might otherwise dislike, or a shopping mall being compelled to allow leafleters it might otherwise dislike. And the focus is, and I believe this is a kind of later explanation of Turner Broadcasting, is the reason for Turner Broadcasting coming out the way it did is the programming offered on various channels by a cable network consists of individual unrelated segments that happen to be transmitted together for individual selections by members of the audience. Not so for a parade, right? Parade, it's not individually selected. Parade, people watch the whole parade or part of the parade. But for channels, they switch channels. They find the channel they want. And that, I think, describes to a T how people experience Twitter, let's say, where they, generally speaking, setting aside the recommendation function, follow those people they choose to follow, or Facebook, where they go to the pages they want to go to, or YouTube, where they watch videos that they want to watch. So with that, I close for now and turn things over to Tosh.
Shall I proceed? Marshall, I think you're on mute.
Can you hear me now?
Yes.
I apologize. I'm the original Luddite. I was thanking Eugene for a provocative presentation and in particular an intriguing use of Citizen United that I hadn't thought about. And I'm pleased to throw the internet over to Ash for his response. Thank you.
Thank you also for having me. I'm looking forward to this very much. I just want to start off by saying that I actually agree with Eugene about the hierarchy that he described. In fact, I completely agree with it. I just disagree with him about specifically where social media platforms, and those are the kinds of platforms I'm focused on, rest within that hierarchy. I want to start off by briefly making a point that I think is not terribly contested, which is, I think, contrary to Justice Thomas, the argument that under current law, social media platforms are qualify as common carriers is very weak. They simply do not possess the kind of physical bottlenecks, such as a toll bridge across the Charles River, to use Thomas's example, or legal monopolies, franchises, that traditional common carriers have possessed. The Justice Thomas suggests that it doesn't matter because you can always swim across the Charles River. I would suggest that swimming across the Charles River instead of taking the bridge is a rather bigger burden than switching from Twitter to Parler, a couple of clicks. And I think that's a fundamental difference, which is that really common carrier law historically has been based on resources that are essential, that really someone has to use. And I just don't see social media platforms that way. Second, I think that the market power that such platforms possess is fleeting. It's not lasting in the way that a physical monopoly is. Frankly, Facebook is in trouble. It's why it changed its name, among other reasons. It's losing users today and seems to be in decline because no one under 40 uses Facebook. And that's a demographic dead end. That's one of the basic rules of marketing. If you lose all young people, you don't have a future. And there's Instagram, and maybe we should force Facebook to spin off Instagram, but I just don't see that kind of monopoly. And we don't want to treat common carriers as monopolies. We don't want to treat social media companies as common carriers. We don't want to franchise them. We don't really want to regulate them heavily regarding their rates or anything like that. So that's one point. On the First Amendment point, it really is a question of, do common carriers provide are they closer to newspapers in providing a curated experience, or are they closer to telephone companies in providing transparent communications? Because newspapers have well-recognized First Amendment rights. The Miami Herald versus Tornillo case that Eugene mentioned is the prime example of that. On the other hand, even I don't think that telephone companies have First Amendment rights as common carriers. Though interestingly, then Judge Kavanaugh thought that internet service providers did, which sort of stuns me, but I don't agree with that. But I'm going to use Facebook as my example just because it's the platform I'm most familiar with. They are clearly providing a curated experience. They do not provide transparency. If they did, no one would be complaining. Right? I mean, Justice Thomas's complaint about these platforms is that it's a response to the great platforming of January 6th, 2020, but that they do control content. But frankly, that cuts against them being common carriers because historically they have provided a curated experience because they want to. They heavily control content. And frankly, this idea that because they are open to the public, they can be treated as common carriers and would lose any right to exclude. Well, that might be true of bridges. And that might be true of railroads using a later technology, or inns to use the classic common carriers. But none of those entities exercise First Amendment rights. The reality is we have always believed that newspapers have editorial rights. We have memorialized that in the First Amendment repeatedly, probably in the press clause. And I think that social media companies look a lot more like a newspaper than they do like a bridge. And to give you an example of why, the cable companies are frankly the closest, hardest question. I agree with Professor Volokh completely. The Turner case is the key case. But Facebook is really different from Comcast. Facebook doesn't permit nudity. Comcast has the Game of Thrones, but it also has on-demand porn. None of that stuff would be permitted on Facebook or on any one of the major social media platforms, all of which have various forms of bans on nudity or pornography. So they really do control content. And I think media platforms have a choice to make. Some of them have to control content, search being one of them. Otherwise, you choose. If you're Facebook, you choose to control content, and therefore you're not a common carrier. But then you're subject to political pressure. And you have to respond to that political pressure and deal with it by saying, well, why are you controlling this content and not that content? The Spotify Joe Rogan controversy that's right now going on, I think, exemplifies this. Because I think Spotify has made a mistake. Spotify is not a social media company. It looks much more like a phone company, in that it's very transparent. It makes recommendations, unlike a phone company. But basically, if I decided to go on Spotify today, and rather than listening to their recommendations, I decide that Russian punk rock is like my current thing, I can access it trivially. The fact that they have chosen not to take that position means that they're subject to pressure to, for example, deplatform Joe Rogan. I do not think they should, by the way. I think they should adopt the common carrier model for themselves. But that is not what Facebook and Twitter have done. And here's why they haven't done it. it would be a terrible idea. Here's the thing to remember about protected speech, is that presumably the position that's been taken has been, and this is Texas and Florida have passed laws to this effect, is that social media platforms should be allowing all legal content on a non-discriminatory basis. But it's important to remember that the First Amendment protects a lot of content that Eric Goldman, among others, has called awful but lawful. So the First Amendment protects hate speech. The First Amendment protects non-obscene pornography. The First Amendment protects outright lies. See the Alvarez case. And, big one, the First Amendment protects praising terrorism as long as it doesn't rise to the level of incitement, which it almost never will. And this is a highly relevant consideration. So it's easy to forget that when Twitter first started, the vision of Twitter was a kind of an anything goes platform. It was much, from the beginning, Facebook has had long and fairly sometimes hysterically funny controversies about what to permit and what not to permit. But Twitter was supposed to be an anything goes platform. Well, why did they stop? They stopped because Twitter had an ISIS problem. Because if you look back on news coverage of Twitter around 2014 to 16, there's constant coverage about the fact that Twitter was becoming a major source of ISIS, Islamic State propaganda. And that under its current regime, because it was lawful content, there was no particular reason or way to block it. And that was why Twitter started to engage in more active content moderation. Turns out they didn't want to be a conduit for terrorist propaganda. And that kind of started them down the path where they have become much more active content moderators. And presumably we think that was the right thing to do. But when we talk about hosting, we tend to think about, well, Twitter could just host President Trump and that would be ex-President Trump and that would be fine. But I don't see, if we say that Twitter has an obligation to host all lawful content, I think they have to host ISIS. I think they have to host pornography. I think they have to host a whole bunch of stuff that is pretty awful. Because I don't know how to draw those lines in ways that make any sense. Because once this government starts tinkering and saying, well, we don't like this content, so you could block it, but you can't block this content because we like it. At that point, I think you've run into a major First Amendment problem because you now have state action. There's a case, Denver Area Communications, that I think supports that position. And so that's, if you want to ask about why I think it's not only unconstitutional, but also a bad idea to move in this direction. It's because I do think that social media firms look more like newspapers. They're not a perfect match, it's third-party content, but still, they provide a much more curated, controlled experience. They want to do so. They do not want their users to associate their platforms with ISIS propaganda, or for that matter, non-obscene pornography. And B, and I think that's as a First Amendment matter, I think it means they do have editorial rights, which can't be written away by Congress by fiat. But B, I think as a matter of social policy, I just don't think it's a good idea to convert these guys. If they really had an unstoppable monopoly, as traditional phone companies did, and as cable companies did arguably during the pre-internet era, I might be able to feel differently. But given that it's quite easy to get around these platforms, as we saw when there was this huge migration to Parler after the January 6th deplatforming, I think that the balance really suggests that we should let platforms provide a curated experience and let people choose. If people want an anything goes platform, including ISIS propaganda, fine. If people don't, fine. But that's not, I don't think this is an appropriate role for the government. And one final point on this, and I will stop. Well, a couple of points. One, these halfway points are tricky. And I want to use the Postal Service example that Professor Pollack mentioned. So the Postal Service is free to everybody. Well, not historically. Famously, the Masses case, which is one of the then District Judge Learned Hand's contribution to First Amendment law, was about the Postal Service blocking the mailing of a left-wing publication. And by the way, the Postal Service eventually won. You look at federal obscenity prosecutions, almost all of the early ones involved use of the Postal Service. to distribute obscene materials. So the Postal Service has always been in this funny position where they've been a little bit censorship, but not too much. And that's really problematic. And I think that's why that model doesn't work very well. So then you're left with Justice Stevens and Citizens United. And there, is private power sometimes a risk to democracy? Sure. Though I actually continue to have a fairly strong faith that the robustness of our democracy is not really threatened by corporate power, which, by the way, that's why I think Citizens United was correctly decided. And my view is that ultimately, despite private power, despite everything, the government remains a bigger threat to robust conversation than do private entities. Especially private entities that, while they have some market power, do not have the kinds of physical bottleneck monopolies that really permit them to shut down debate. And I think I will rest.
Hey, Marshall, I think you're still on mute.
Myself, thank you. Can you hear me now? Thank you. I just want to thank Ash for his presentation, particularly focusing us on the facts of what exactly each internet company does before deciding how and in what way they may or may not be regulated. Now we're pleased to have Judge Van Dyke, our moderator, pepper the speakers with questions.
All right, well, thank you, Marshall. Eugene and Ash, I think what I'll do, rather than jump right into some of my questions I've written down, I do want to give you each a chance to respond to, at least Eugene. I'm sure he's been chomping at the bit to say something, so maybe don't take too much time, but
Sure.
If you don't want to, I've got questions, but I'd like to, I'm sure you heard something controversial, so respond to it.
Sure. So I think I did want to mention a few things, and among other things, I want to mention a few things on which we agree. So for example, I totally agree that if the government imposes a viewpoint neutrality mandate on social media platforms, it has to itself be viewpoint neutral. So if Twitter and Facebook, let's say, are barred from discriminating based on viewpoint, then they can't discriminate against constitutionally protected speech that praises terrorism. I totally agree, and that's a possible downside. You might say, we so want to have them block that such speech that we will let them block all speech that they want to block for whatever reason. But it's certainly possible. This having been said, I think it sounded like Professor Bhagwat and I agreed also that at least for some kinds of internet entities, like maybe hosting companies and the like, at the very least, it would be constitutionally permissible and maybe a good idea to make them be common carriers. And, presumably then they will be carrying messages from the pro-ISIS folks. Would we say, well, Amazon Web Services has an ISIS problem, and it's really important to have them be able to fix that problem because otherwise ISIS messages will be distributed on their property? I think we might say, kind of like the way we say with regard to the post office today. Maybe we didn't before, but ever since the 40s and especially since the mid-60s, we do say, if there's bad speech carried on through the mails, that's on balance better than giving the post office the ability to block things. Likewise with the phone company. Likewise, I think we may agree with Amazon Web Services. I think we might say the same with regard to Twitter and Facebook. As to pornography, it turns out that Twitter actually allows pornography. There's a lot of it. Well, I mean, I haven't counted, but pornography is allowed. It does have to be marked as sensitive. So, maybe that's one thing that makes it less obtrusive. But I don't think I've ever accidentally run into pornography on Twitter. Not even something that has this little sensitive content warning. So it's not that the sensitive content flagging is protecting me. It's just that on Twitter, I follow the things that I want to follow, and I don't follow the other things. So the fact that there's all this awful stuff that might be there, I mean, for those people who view pornography as awful, doesn't really affect people's experience of that any more than the fact that on a phone system there is awful stuff available, maybe dial-up numbers or some such. I don't think that affects our experience with the phone company. It may affect it a little bit more because we're more likely to visit a random page than call a random number, maybe. But on balance, I just don't think it's that much of a problem. And let me close with one other thing. I totally appreciate Professor Bhagwat's point that the platforms are trying to curate. Now, to be sure, I don't agree that Twitter tries to curate out pornography, but it tries to curate out other things. Let me tell you who else tries to curate. Universities. Universities are massive curation engines, right? They curate their curriculum. They choose which departments to have, which majors to offer, which classes to offer within those majors, which content that they usually do through their faculty, but still which content to have in the classes. And the universities in Rumsfeld v. Fair, wanted to also curate what kinds of speakers come onto campus in order to do recruiting. And, you know, they were actually pretty broad-minded because they want people to recruit their employees. But, you know, probably if somebody wanted to come with pornography, they might have said, nope, you can't. You have display pornography in the recruiting menus. There are probably all sorts of things they were entitled to do. But when the government says you cannot exclude military recruiters, the Supreme Court unanimously says that is a constitutionally permissible prohibition on exclusion. You universities may be wanting to curate all sorts of things, but as to this, you're not entitled to curate. That, it seems to me, is quite closely applicable here.
Ash, you have any thoughts and response?
Yeah, brief response. And I'm going to make it brief because I think questions are good. I agree that I think certainly ISPs, so long as they maintain local monopolies, which effectively they do. In my house, I have no option really but to use Comcast as my internet service provider. If that monopoly is broken by 5G, different story, but for now, common carrier status is fine. I wouldn't have an objection to extending it to AWS as well, because again, they don't really have any association with the content they host. You know, their hosting services like that are very much just providing it's like a printer. They're providing a neutral commercial service. But I think with platforms, it's tricky because I think this is probably why Spotify has not been willing to go all the way it has, is that it doesn't want its users to find a podcast on their platform that says, this is why ISIS is the best thing since sliced bread. Right? There is this idea that there is some curation. Now, I think in Spotify's case, they may be making a mistake because they really don't really want to curate because, you know, there's a lot of music that people have ideological objections to. But I think in the case of something like Facebook or Twitter, they've made a choice to not want to be transparent. And because they don't want that, they want their users to associate their platforms with a particular set of values. Apparently no problem with porn with Twitter, but terrorism, they've got a problem. I find it as a matter of First Amendment law, as a matter of policy, troubling for the government to overturn that choice on their part, as long as it's being done consistently. I certainly agree that the government can insist that they follow their own content moderation policies. That seems like a law of contracts issue. But as long as they are, that's sort of where I lie. But let me actually stop there and really open it up for the judge.
Let me ask a question. Eugene, I'll direct this at you, but obviously I want to hear what Ash says on it. And it's related to something you talked about and actually related to what Ash just was talking about. You know, it's one thing to think about these social media companies doing something for a finite small amount of material. But, you know, these social media companies, the ones we're talking about, Twitter, Facebook, et cetera, there's so much material, probably even Spotify, you know, there's just so much material on there. It's hard for me to, I'm particularly curious because of your computer science background, Eugene, on this. Like, it's hard for me to envision how, I mean, I think you used the word information overload at one point, Eugene. How could, given the sheer amount of information that's on these companies, and will presumably be on any social media company of any size, just because they really are global in scope, is there really a meaningful distinction between I think you talked about hosting versus recommendation, but hosting, I understand the difference for AWS and these other, they are just kind of hosting, and it doesn't have to do the content, but any kind of social media company that's interfacing with the public, how could they actually get away from curating of some sort? Like, it's hard for me to imagine that they could, and if they, because you mentioned the Twitter porn example, there's got to be some way, even if you do a search, even if you're looking for something. I think Ash had said, if you run across some sort of ISIS thing, but even if you do a search, there are algorithms that are curating within that algorithm.
Right,
So
totally.
can you get away from that?
Sure. So first of all, I should mention common carrier is shorthand for a bunch of different possible models one might have. One of them might be, for example, viewpoint neutrality, but not necessarily content neutrality, something like that. So we might want to think a little bit about that. Another thing is that, remember, I do think it's really important to distinguish the various kinds of functions. And I talked about recommendation function, talked about the hosting function, mentioned that the comment moderation function is probably more complicated. Then there's the search function. And I think it's really complicated because Rumsfeld there is really complicated. But I do think that while it may be permissible to require platforms to, if you look for real Donald Trump, for them to find real Donald Trump, the account at real Donald Trump. If you just look for COVID information, for them to give you what they think is good COVID information, not bad COVID information. That is, in a sense, like the recommendation function. It's like the Google search, right? So one way of thinking about it, let's think about Rumsfeld v. Fair. Rumsfeld v. Fair not only required universities to host military recruiters, it did require them to include some speech about those recruiters. So, for example, if the university is going to send out a newsletter which says, here is where all of the recruiters are, then it could be required to include the military on that list. I mean, imagine the university said, okay, fine, we have to host the military recruiters, but we're not going to tell anybody what room they're in, right? No, it's pretty clear from Rumsfeld v. Fair that the university could be required to do that. Likewise, if it's pretty normal for somebody, if somebody's looking for a recruiter to go to the information desk and ask where they are, then the information desk might have to answer when they're asked, where's the military recruiter? On the other hand, if the university, if the law school wants to say, here are our favorite recruiters, here are the recruiters that we most want you to talk to because we think they're the best, then I think it's quite legitimate for them to not include the military if they don't think the military is the best under whatever metric. Likewise, if they're being asked, what's a good recruiter for dealing with criminal law issues? And then they recommend the PD's office and the DA's office, but don't recommend the JAG Corps. I think that they would be entitled to do that. They'd have a First Amendment right to do that too. So I do think these are the kinds of things that routinely have to be answered, the kinds of lines that routinely have to be drawn. And I think they are drawable.
Ash, do you think they're drawable?
I think they are drawable. I want to emphasize something, which is I think the distinction that Eugene has drawn between hosting and everything else, I don't think it's consistent with traditional common carrier law, which really had a very strong non-discrimination requirement that was at the core of what a common carrier was. And at least the legislation that I have seen coming out of Texas and Florida tends to extend viewpoint neutrality rules to recommendations as well as hosting. So I think that the position that Eugene has taken is by far the most defensible among the various positions about imposing non-discrimination requirements. I still disagree, and let me give this analogy. We're talking about Rumsfeld. So, and let's talk about private universities, because public universities themselves are bound by the First Amendment. But a private university is told you have to host military recruiters. Well, okay, that's 9-0, I agree. Private university is told you have to host visiting lecturers viewpoint neutrally. So if the head of the KKK wants to come and give a lecture, you got to host them. If the head of the Communist Party wants to give a lecture, you have to host them. I'm fairly confident every single Supreme Court justice would find that to be unconstitutional, 9-0, because because universities do curate content, and I'm talking about private universities again, because like I said, the First Amendment overlay with public universities makes things complicated. The question then becomes, what's the better analogy? The military recruiter or the lecturer? And I continue to believe the lecturer is the better analogy when we're looking to social media. Then that is why I think even hosting is problematic if you want to give a curated experience. And again, when you talk about curated experiences, think about not some sort of completely non-ideological university, if there is such a thing. Think about universities with clear ideological sort of associations, like Liberty University or something like that, who consciously want to curate their educational experience. I do think that it would be completely unconstitutional to require those people to host speakers they don't like.
I'm kind of puzzled what the constitutional distinction would be between speakers who speak about why it's a good idea to come work at their controversial place and speakers who come again to speak to a willing audience and say, here's why it's a good idea to embrace my controversial views. And by the way, you know, for whatever it's worth, the Supreme Court has not passed on this particular issue, but I believe in Pennsylvania and certainly in New Jersey, universities are included under this Prunier doctrine of having to allow speakers, outside speakers, to come onto their property, private universities, on their own property and speak. Now, maybe there's a First Amendment line you're suggesting between speaking inside a classroom versus speaking on the quad, but not as to the recruiters who are allowed to speak inside the building. Not just on the quad. It just seems like that would be a strange constitutional line to draw.
Well, it's clearly a very difficult line to draw because the recruiters, I just feel like the burden on the First Amendment is very small, given that, you know, after all, and we're talking about law schools, let's be clear, right? Because law schools were the ones who pushed this. Law schools permit lots and lots and lots of recruiters to come on their campus whose views they don't agree with, right? I mean, they are going to allow both the ACLU and the Pacific Legal Foundation on because the main function, after all, of our recruiting program is not some sort of ideological statement, it's to get our students jobs. When you start talking about public speaking, not in classrooms, halls, whatever, it becomes much more part of the educational experience, and that is kind of where the line would be. And I think speakers on quads is tricky. It's right in between. And these are thin areas. I agree. Bright line rules are very hard to draw here. And we've ended up talking a lot about college campuses, which is silly. We should be talking about social media. But that, again, it's really about what is the right analogy.
Well, Ash, I want to follow up on something you said earlier. You talked about how, and I think you make good points on the fact that social media companies, you know, it's hard to get away from the idea that they're curating content for a variety of reasons. One is just the sheer necessity that we've talked about some. But one of the things that sort of has occurred to me is that maybe what has some people frustrated is a disconnect between the way they feel like some of these companies are portraying themselves and between what they're doing. So, you know, nobody, that maybe they feel like these companies have tried to intentionally cultivate an image of being impartial conduits for other people's expression. That's typically what you think of, for example, just to use Facebook, is that, you know, there's that you know, you're seeing your friends, what your friends are posting. That's sort of the general idea. But people will get frustrated when they feel like, you know, something happens with that seems to indicate that they are actually putting a strong thumb on the editorial scale, which I agree they're doing, and if you look closely, that's what they're doing. But there seems to be this disconnect between, or at least there's a perceived disconnect between sometimes the way they present themselves and the way they actually and what they're actually doing. And so, I mean, in some ways, I think it's perhaps similar to the mainstream media. You know, the old-fashioned TV shows, they were the old-fashioned news. You know, obviously, all the news services say they're fair and they're fair and impartial and unbiased, but hardly anybody really thinks they are. I mean, if you took 10 people, they really and I think that maybe and that's probably something that's developed over time, but I would say more people think that the social media platforms do sort of are more fair and unbiased. It's just like, you know, even saying we're going to give fair and unbiased information about COVID, just to use an example, right? So we're going to put out stuff we think is not consistent with with the truth about COVID, but then some people would say, yeah, but you're kicking out stuff that is true. So with all that going on, is there any way, if that, do you think that is an accurate maybe basis for some of the frustration that people are having? And if, whether it is or not, is there any way, any kind of regulation that could be done, sort of a Prop 65, since you're both from California, Prop 65 warning that does absolutely no good, but they're ubiquitous, right? So maybe maybe this isn't a good example, but a Prop 65 type, there's something that's not a Prop 65 warning that says, some sort of transparency device that says this is really what we're doing. Is there anything that could be done in that respect that would still allow them to curate the expression the way they want to curate it, but maybe be a little more transparent about what they're really requiring? And maybe I'll have Ash respond first, and then Eugene on that.
So I think that the answer is maybe. On these issues, I describe myself as a moderate libertarian, in the sense that I have no objection to, first of all, I have no objection to antitrust laws being applied to media platforms. But second, I think that some forms of disclosure requirements are probably okay. These guys clearly have written content moderation policies, and they have big guidance documents that tell people how to apply them. Facebook's content moderation machine, it has to be called that, has unbelievable numbers of employees worldwide. Of course, they're providing guidance. And I think requiring transparency on the guidance they're providing is fine. I don't have a problem with that. And then if they're not following their rules, they can be called out for it. Whether there is political bias on social media, I think the answer is historically, the answer is probably no. I think during 2020, there may have been some bumps. And I think this is where really part of the problem lies, is that these guys are in between, because they feel like they need to respond to political pressure on both sides. And I think that the reality is, I think that the better solution is just to leave them alone and let them do what they want. Because the problem is they're getting absolutely opposite pressure from the two sides, right? I mean, generally progressives in Congress want these companies to do a whole lot more content moderation than they do, while more conservative voices want them to do less. And to my mind, that itself suggests that there's a problem here, which is that everyone seems to believe there's a Goldilocks solution, and I don't think there is. I think there's always going to be mistakes. I prefer labeling to outright blocking, unless someone sort of has so thoroughly flouted your rules that you have no choice to block them. I think that there are more sort of controlled ways of doing content moderation, but ultimately, I would much rather leave it to media companies, the social media companies, and if people decide they're hopeless, people will leave.
Well, so I appreciate the pressure that private businesses are under. I'm generally not someone who's very skeptical of corporations. They are run regrettably by people, and people do bad things and foolish things and make errors some of the time, but boy, I think we ought to be thankful to a lot of these companies for setting things up, for making it possible for us to do this with people watching us from across the country. So I sympathize with the pressure, but you know who doesn't have to worry about pressure? The phone company doesn't have to worry about pressure. UPS and FedEx don't have to worry about pressure. Nobody says to the phone company, why is it that you still have Joe Rogan's phone number? I mean, I assume that his company has phone service, right? Nobody says that to them because they have a perfect answer. It's the law. Don't look at us. We're not in the business of deciding this. Now, maybe if we do have some kind of page of our own where we recommend particular phone lines that are particularly useful, we won't recommend his. But in terms of him talking to people who want to call him, and then that's fine. Likewise, I've been hearing in fact, actually, I was called to testify before a subcommittee on this question, having some concerns about 501c3 status, nonprofit tax status being used by extremists, by hate speakers. My answer is yes, of course it is, because the government can't discriminate based on viewpoint in deciding who it is who gets this kind of subsidies that is essentially the 501c3 tax exemption. And my sense is that there's not a lot of furor about it because, in fact, I'm not the only one saying this, that their lawyers say, no, there's no point in trying to go after the IRS, and why is it allowing these things? Because it has to allow them. So likewise, if we're concerned about pressure, it seems to me in many ways a common carrier model will diminish that pressure. Now, maybe it'll do it at too high an expense. Maybe we want them to be able to curate, as Professor Bhagwat points out. But I think in many ways that it could make things easier for them if we tell them they can't.
So here's the thing. I agree with you. It's why actually I think Spotify should voluntarily simply say we're basically going to treat ourselves as a common carrier because we don't want to be deciding if Joe Rogan goes, who goes next.
Mm-hmm.
I think that these firms, for reasons having to do with Twitter and ISIS things in that case, in the case of Facebook it was the original vision, don't want that, right? It would ease it. I mean, frankly, from Facebook's perspective, if Congress made them into a common carrier, they might pop some champagne and say, well, we don't have to worry about this anymore, except that I think they're afraid that it's going to kill their business model because of the sewage problem. That there's just there's sufficient sewage on the internet that is lawful but awful, and they just don't, if it starts to get associated with their platform, because they might run into a problem of losing users.
Well, so let me probe this, because I do think this is a very important point. So it seems to me that there are two kinds of sewage. There's the kind of sewage that seeps into your normal plumbing. That's the comments. That's why I actually think that there's a lot to be said for platforms retaining the right to block comments, because those appear when I'm reading your Twitter feed, but somebody else is intruding. And then there's the sewage that might appear to people who call dial-a sewage, and they get the sewage. And then what's it to me that they have the sewage? Now, maybe people will get really upset and they say, I refuse to patronize this place because it has evil people in it. But if indeed they're required to do that, then their answer is, well, it's not our fault. And I suppose somebody would say, I don't care if it's your fault. As a matter of moral principle, I refuse to go to a website where I happen to know that there are communists who are also on that website, even though the website has to host. I think that there'd be very few people who are quite that militant about it. And they'd say, okay, fine, I understand you have to host it this way. By the way, the same thing came up with Rumsfeld v. Fair, right? Universities were saying, we're getting all of this pushback from our stakeholders. They can't stand the fact that military recruiters who are discriminating based on sexual orientation are doing these things. They're threatening all of this stuff. And the court's answer is, well, if you tell them that you have to do it, that it's the law, presumably they'll understand that you're not endorsing it and they won't really take it out on you. And if they still do, well, too bad.
So here's the interesting point. If you are correct, then I would think that Zuckerberg should be out there actively lobbying for common carrier legislation, because all his problems would go away. But he's not. Right? I mean, because if you're correct, so all of this pressure, this constant being called, I mean, there's the whole data leaks thing, that's separate, but the constantly being called in front of Congress and saying you're spreading misinformation, you're spreading hate speech, he should be the one saying, please help me, make me a common carrier.
Well, maybe, but I would think that there may be two reasons, at least, that he might not. And one reason may be that there are actually real costs to any kind of regulation, that nobody wants to be regulated because, who knows what will happen if you won't entirely comply. So I totally see that as a downside of regulation, but there are two possible reasons. One is he might think there'll be political pushback, at least in the meantime, before he gets what he's lobbying for. People say, oh, Zuckerberg, he's lobbying for common carrier status because he is not on board with our program of purifying the internet. And he might say, yes, I'm not on board with it, but a lot of people might push back on him because of that and might take it out on him and his company. The other possibility is maybe I'm not sure about him, but some people maybe at Facebook and maybe he like the idea of having the power to, at least in some situations, say, oh, no, I'm going to block it. Maybe even because I'm maybe they even frame it as a public spirited thing, like I am going to be the salvation of American democracy and such. I'm not sure that's in fact his view, but I do think it might be the view of at least some people in Facebook that would make them want to retain power. Many institutions like power, including political power, and this does put him in a position of having an expensive form of political power.
True. I mean, and it's hard to know.
Hard to know.
I am quite confident that the New York Times is very happy with the influence it has with its readership, right? I mean,
yes, exactly.
And even more so Fox News.
I'm sure they do. I'm sure they are.
So I am going to ask one more question, and then I'm going to read. Right now, it looks like I've got a couple questions that have been submitted to me, but please, please feel free to submit some more. But I'm going to ask one more question. And I guess I'll direct this initially to Ash, but obviously I'm curious what both of you think. And the reason I'm directing it to Ash is because Ash, you mentioned that it's easy to get around these platforms. You know, I think you mentioned the example of Parler and Twitter, and you I think you also early on had talked about, you know, usually common carriers where there's some sort of physical bottleneck or I guess an economic bottleneck, a monopoly. Or involving something like an essential resource. And those things all make sense, but it seems to me, at least a lot of people are thinking that for whatever reasons, and I don't purport to know what all the reasons are, that it is actually really hard to sort of create. You would think it would be super easy, right? You know, somebody in their garage could just create Bookface, you know, and it would be the alternative, right? But it seems, you know, Parler, my understanding is that Parler hasn't really done that great, you know, comparatively. So one of the things that seems interesting to me is that politicians on the right, if you were to give them some survey about what they think of Twitter, I'm guessing that the numbers would be very high as to the fact that they hate Twitter and they think this and that about Twitter, but they all use Twitter still. So that to me says something. So is it really true that, I mean, see, isn't there some evidence that something like monopoly power is going on, or even if it is a traditional monopoly power?
I mean, there is certainly the reality of network effects certainly means there's some lock-in function, but it's the fact that in fact the younger generation has found Facebook to be quite unnecessary suggests that that shouldn't be exaggerated. I mean, and to be clear, I am very much supportive of taking steps to prevent current platforms from entrenching themselves. I think it was a mistake to let Facebook buy Instagram, and we should have forced them to spin it off ages ago, because that's the kind of thing where I see absolutely no value in lots of bad stuff for society. But I actually don't think it's that hard to move to a different. I mean, look at the rise of TikTok, you know, which went from nothing to being basically the dominant platform for young people today. I don't think the barriers to entry are that large. I think the percentage of people who actually want totally uninhibited conversation is relatively small. And I think that's why Parler remains a niche service. In many ways, Twitter is also a niche service, right? I mean, its reach is nothing compared to Facebook, largely because most people do not use Facebook for political reasons, right? And I also think it's easy for us to forget this as lawyers. Most people don't care that much about politics, right? I mean, they're interested in their stuff, what they made for dinner, like was it a good recipe, right? I mean, it's just, and I think that we sometimes forget that social media platforms' primary function, at least for platforms like Facebook and TikTok and Instagram, is not political in any sense, right? I mean, that's almost a side function. Twitter is different. Twitter is the preferred platform of journalists and politicians for reasons we could talk about.
I want to hear Eugene's views on this, but it did trigger sort of something related to our last question. Given that some of these platforms, I agree with you that these platforms like Facebook and Instagram are not primarily political, and because they're not, but they also have massive reach, right? And so because they're not primarily political, is that an explanation why, you know, the questions that you were both talking about earlier as to why, you know, I should say, why aren't they going to Congress saying, you know, regulate me? Because maybe they like to have the ability to, you know, they have their main business over here, but come political season, maybe have some influence. Is that a possibility, or do you think that's conspiracy thinking?
I am confident that is not how things started. I am confident that in 2016, I think that before 2016, that was not at all on the minds of any of the social media platform owners. They really did see themselves as transparent. I think that the Russian scandal with the Russian accounts really changed their perspective, partially because they themselves gulped and partially because they came under a lot of political pressure, bipartisan political pressure, about their being used to manipulate public opinion. And that was the turning point. Now, maybe that was a mistake. Maybe our answer is, well, we're okay with, the Russian government, Vladimir Putin, using social media to sort of create dissension in America because he can use the phone call as well. And I think that's necessarily the common carrier position, right? Is if not Putin, he may not have First Amendment rights, but a Putin follower in the United States, and there are plenty of them, right? I think that's when things changed. And the question becomes, was that a mistake? Right? I mean, we're dealing with 5 years later, the fallout from the pressure that came on social media in the wake of 2016. And they shifted towards a much more aggressive content moderation policy on political issues. And that's the fight, not a fight, the disagreement that Eugene and I are having is, I think that probably on balance was a good thing. I think necessarily the Volokh-Thomas position has to be that it wasn't, that we should go back to the old days when anything goes.
Well, so I think it's possible to have a common carrier rule that, as I said, is viewpoint neutral, that focuses, for example, on whether some entity is an American, some speaker's an American citizen or American company or whatever else. Again, that would be maybe still be something the government can't just impose as a categorical matter, but it would be a viewpoint neutral feature of a common carrier regime, that you could, if you want to, block based on foreign identity, but not based on viewpoint. However, if really we're thinking that Facebook is going to start to block people because they think they're Putin followers or Putin fans or Putin supporters, I gotta say, as someone who is very far from a Putin supporter myself, that is really something quite frightening, because they could presumably block people because they're supporters of Palestinians, or block people because they're supporters of Israel, or block people because they are supporters of China, or block people because they're opponents of China. Do we really want platforms to have as part of their vision, we're trying to make the world pure from those awful anti-China racist forces, right? I gotta say, that's something that makes me a big fan of the Citizens United dissent, again, as applying to the situation. Let me give you one particular illustration. So recently there was this news story about the highest ranking woman admiral in American history. Turns out that this person is transgender, was born male, now identifies as female. I don't know exact details of operations and such. Unsurprisingly, some people who believe that your true gender is the one you were born with, or first approximation, you might press them a little bit on people who are intersex and such, but that is a first approximation, disagreed and posted things saying, this person is not really a woman, he's a man. And Twitter blocked that. Now, first of all, I don't think we need to debate whether this is ideologically biased or not. It is self-consciously ideologically biased. It reflects Twitter's decision about a particular ideological question, which is, what is a person's real gender? How should we treat people who are anatomically or chromosomally, or however some people define it, again, different people define it differently, or one thing, but identify and act socially as another. So Twitter decided to make this decision. Now, ultimately, the fate of the Republic doesn't rest on that. But I think, first of all, 10 years ago, we would have been shocked at thinking that Twitter would make that decision, not just as to ordinary random schmoes on Twitter, but as to people talking about one of the highest level military appointees. I think this person was not in a warfighting role. I think they have been medical service or some such. But still, you'd think in America, you're entitled to criticize admirals include, for whatever reason you think is right to criticize admirals. So one question is, what are they going to do 5-10 years from now? Especially now that they've gotten a taste for it, now that they've had their identity be set as being, we have been told we're the protectors of democracy against evil, hatred, and against misinformation, and against anti-transgender ideology. So that's what worries me. And maybe none of it will happen, and maybe it'll only be relatively marginal stuff as a descriptive matter that's going to be effective. But I think once they develop a taste for this sort of thing, it's hard to see why they wouldn't do more, as they've already been doing more and more with every year.
Well, I mean, by the way, I agree with you. I think it would be very bad if social media forces decided to start blocking Putin supporters. And even this example, I agree with you, probably a mistake. But though, the question is this: are we going to allow platforms to make those choices and bear economic consequences, which I think at some point they will start to bear, because after all, not everyone in this country is woke. Or are we going to have the government step in and decide what the model should be? And that's the question, right? And
right.
I find myself unusually being on the strongly libertarian side of that question. But we should definitely.
And maybe you're right. You may very well be right.
Well, let me go ahead and ask take the first two questions and try to put them together, since we're getting lower on time. And the first question that I got was somebody asking about if somebody says, we reserve the right to essentially exercise editorial oversight, right? If a social media company, but they never do, or they rarely ever do. Should they be treated as a common carrier? So that's the first question. The second one's kind of similar, which is if a company says, an example that was given in this question was Twitter CEO, going before Congress and saying, we're a public square and we emphasize the importance of free and open exchange of ideas. But putting aside the specifics of Twitter, just generally speaking, if a social media company, either through its leadership or its policies, presents itself in a certain way as being, an open forum, but then as a practical matter isn't, is there, what should be done about that? Or what should the government do to try to sort of Prop 65 warning again, something to hold them to, or something stronger, but what should be done? So remember, the first one is they reserve the right, but they hardly ever do. Can you look at that and say, since you hardly ever do, the fact that you did it in this one instance?
I should say, I to the extent people sort of think of this as, well, they're breaching their contract. Not that I'm saying you're saying it, but I've heard other people say that, puffing, I think, is a very important concept for first-year contract law. By the way, it reminds me of my favorite article title.
It's a promissory estoppel argument, Eugene.
Well, right, but it's puffing. People recognize that it's not a binding promise. My favorite article title is, I forget who wrote it. It's called "The Best Article Ever About Puffing." But the concept is I think quite accurate. That people say things in general, and when they're framed that generally, people understand that. So when the New York Times says all the news that's fit to print, or when Fox News says fair and balanced, you can't sue them saying, no, you didn't print this, even though it was fit. You're not being fair and balanced here. You're right? People understand that this is puffing. But there's a deeper point, I think, what you're getting at, which is, I do think in some respects we do distinguish something where people take steps to include versus take steps to exclude. The classic example of that has to do with government-owned property. So there is state action. So I agree this is different. But it has to do with what it takes for something to become a limited public forum. And if the government just says whatever it wants to say, then that's government speech. It's not a limited public forum. It can choose based on viewpoint what it wants to say. If the government invites some favored speakers, like if I'm running a speaker program at UCLA, kind of like this program, although at a public university, of course, we're entitled to pick people based on viewpoint for a variety of reasons. Maybe academic freedom notions should suggest, or academic freedom, but academic notions generally suggest that we shouldn't be too close-minded, but we could certainly choose. We have to choose based on viewpoint in deciding whom to invite. But once you basically say everybody can show up, any student group can invite anyone they want, and then say, oh, but not these ones. Not this one. Then it seems to me it begins to look more like a limited public forum where it's not the government that's speaking, it's the government opening up space to speak. And that's when we kick in the viewpoint neutrality rules. There's an analogy to that might be drawn, it seems to me, with regard to social media platforms that may help explain why we treat social media, why we treat phone companies and UPS differently from newspapers. The newspapers have to constantly pick and choose, and they do, whereas the others would only exclude a few things on the margins. But maybe not. Maybe, as Professor Bargwet is suggesting, maybe there's such value to this ability to exclude, even if by default you include everything, that should be allowed.
I mean, I think what I'm going to say is largely repeating, which is that it's a problem. I mean, I agree. I mean, I don't like the idea of these platforms saying that they're viewpoint neutral, but quite clearly not being viewpoint neutral as the definitions of what falls outside acceptable discourse expands. But those are not easy lines to draw. And again, if we're going to have, maybe we have no rules. That's the common carrier approach, that we just, everything is okay. You can say the Holocaust didn't happen. You can say whatever you want, right? And that's a model. I just don't think it's the model that the social media companies want. Once you grant them discretion, are they going to make mistakes? Of course they are. Of course they are. The worst possible model is, of course, the government deciding what's acceptable and what's not. And I think we can all agree that's off the table. There are lots of people in Congress who don't agree with that, but I think we can all agree that's off the table. So then you really have a choice between let the carriers do what they want or have a common carrier model and have them basically have no discretion. And you know, I mean, the downside of the discretion model is they will misuse it sometimes, unquestionably. The downside of the no discretion model is that Holocaust denial becomes something that Facebook is hosting now, right? And again, this comes to these things where, well, maybe we can take extreme positions on facts. Not really. There's no distinction between fact and opinion that really stands in most instances. So I really don't think there's any choice but saying, let the platforms decide and let's go full on common carrier. And if I really believe that these platforms were true monopolies, I might be convinced that the common carrier model is the right one. This is where Eugene and I are really not that far apart, right? I mean, in terms of the fundamentals, I think we largely agree. It's just a question of, do I think that their power is so important that I want to convert them into something totally different? And I think we're not quite there yet. And in fact, I think we're going to head in the opposite direction, because I think these platforms are going to lose rather than gain reach as other platforms rise. And remember, we were convinced that Microsoft was going to rule the world in the 1990s, and that's why we went after them in our antitrust suit. And now we're after Facebook, and I suspect that probably whenever the government files an antitrust suit, it means that the company is going to drop anyway. Maybe that's the rule of tech law.
That's a very good point. So we're about out of time. What I want to do is give you each a minute or so to, if you have any final thoughts. It seems to me that, as Ash was just saying, you're not really far apart on the principles. It seems like Ash is saying, yeah, this might, like many other things, this might sort itself out, like sort of a free market sort of approach. And I don't know that Eugene is saying different than that, but he is expressing some concerns, because perhaps these guys have the ability to, kind of like monopolist actors, to really affect the ability to make these, for the market to fix these things. Do you have any final thoughts or anything in response to that last comment? Eugene, why don't you go first?
Sure. So I remember when I got radicalized on this, not that radical, but I got to the position which was not my position from the get-go. And that's when big tech, in this case, Google and Apple and Amazon Web Services, demanded that Parler switch to imposing the same kind of essentially censorship rules, not exactly the same, but similar ones to the ones that the other platforms had. And I remember thinking, well, here's Parler. It surged in part because of what was seen as the problems with a liberal, let's just say, restrictions on certain conservative views on Twitter. So there was Parler. It seemed to be thriving. We had an account there and such. And then basically big tech said, after saying, oh, start your own, the reaction was, oh, you started your own. We don't like yours. And because everything is interconnected in a considerable way, right? There's Amazon Web Services doing the hosting, there's the Google and Apple stores and such. They have a lot of leverage. Now, Parler eventually came back as, I think, a shadow of its former self, came back after several weeks of trying to rebuild, because it had apparently a billionaire backer who was willing to continue backing it. But I think the message, my guess is, came out to other entities that if you are trying to depart from this orthodoxy, if you're trying to come up with this alternative, then we may very well go after you. And you might lose all your investors' money, which is not something investors much care for usually, unless they're very ideologically minded. Even then, they don't much care for it. So that's what worries me. And maybe on balance, I totally agree that there's no problem that couldn't be made worse by government regulation. And on balance, most of the time, it does make things worse. So maybe this will be another example. I completely sympathize with that concern. And that's why we should be very cautious about this. But I gotta say that you have these very large, very rich, very powerful entities that are quite interconnected in the sense that you need to interact with them in order to be a player in a lot of these situations. And they've been flexing their muscles, and I think we've got to think a little bit about whether that's a danger to our democracy.
Thank you, Eugene. I figured, given Eugene's comments, I have this coffee cup that says, "Government, if you think our problems we create are bad, just wait till you see our solutions." So
There you go.
that seems consistent with something both of you
Very,
said.
very good point.
Why don't you close us out here?
So I'm going to start off by agreeing. When Apple's App Store and the Android App Store dropped Parler, I was very troubled. That just does not strike me as being a good solution at all. And given that Google owns YouTube, it also strikes me as being pretty much outright anti-competitive, since social media platforms competing against each other. So yeah, I'm in agreement there. I think that there are definitely aspects of the internet that actually should be subject to some regulation if they won't self-regulate. No one thinks that the Apple App Store is a curated experience. No one thinks Amazon Web Services is a curated experience. And I would be quite comfortable, because I don't see those people as being First Amendment actors, that we choose to regulate them. Whether it's a good idea or not, that's a different matter, but I don't think there's a constitutional barrier to it at all. And there are people, by the way, who think that I'm giving up too much when I say that, but but I still think that when we start talking about platforms, and I used to be on the line on search engines, but believe it or not, you, Eugene, convinced me that search engines fall on the side of platforms, of social media platforms. They really have to be curated, and they should be curated, and therefore we should let be and see how things work out, at least for now.
Well, thank you both. This has been wonderful, lively debate. And thank you again, Catholic University School of Law, for hosting it for us. And I'll turn it, I think, back over to either Marshall or AG.
I'm going to take it from here. Judge, thank you very much. Thank you, Eugene Falk and Ash Bhagwat. We had a memorable beginning to this series, and you're all a crucial part of making this the event we wanted it to be. A recording of this event will be available on the Seigenthaler Debates website, linked through our law school's homepage. Many thanks to all of you who participated tonight as the audience for this inaugural event, which has provided an important and deeper understanding of the issues discussed. Look for us to return next year with a new First Amendment debate in the series. Until then, good night.
Thank you.
Thank you.
Thank you very much.